All right. I'm sorry I'm kicking this off just a little bit quicker than 5 minutes, because it occurred to me there's actually going to be 4 recordings for this session, so I'm going to have just a little. Yeah, this is only little. I've got like 3 slides, and so I'll probably even have to do this. Chop it off. Close that. Or reload it. And the reason for that is that these doctrines, unconscionable dealings and undue influence, have similarities in that they overlap in terms of third-party dealings, and they overlap in terms of their remedies and defences. So I probably should have put them all in one recording now that I think about it, but nonetheless I didn't. So we've got to do these things separately. And so I have to wait for this to pop up. But just while that is popping up, okay, there is now, the idea here is that, look, you could have a situation where a transaction, from my perspective, I'm selling my boat to Martin, that could be perfectly fine. But somebody else, Leanne, could actually be the person exerting either undue influence or unconscionable dealings in relation to this transaction. Okay? And so just make note that this stuff can actually still be a vitiating factor if a third party does it. Very similar to how we had duress in the situation where a third party comes in and threatens it. And it's really this flows from a couple of things. It's to do with knowledge. That's really this key part. If you're doing something with knowledge, either actual or constructive knowledge, by constructive knowledge, I ought to have known. I ought to have been suspicious. I ought to have been unawares in relation to this particular transaction, because Martin was acting really odd and letting me go through and do this transaction for a really low amount. That's really what this is about. It's not in good conscience. Sorry, it's not in bad conscience. A court of equity doesn't really care if the amount was arm's length. Right, that doesn't really matter. But it does care if the transaction is somehow tainted by a third party coming in and doing the same thing. So rather than me actively seeking to exploit a special disadvantage, or me exerting undue influence on Martin in relation to this, if a third party comes in, in those circumstances, it can, in some situations, also be a vitiating factor. And the primary circumstance that I'm going to talk about now is what we call, I love this phrase, it's hilarious. It's called sexually transmitted debt. Great phrase.
Isn't that called marriage?
Yeah, something like that. That's it. That's right. Why on earth am I teaching of this? It's the rule in Yerke and Jones. This is also known as. It's a quirky component of our contract law system that when a wife, and only a wife, acts as a guarantor. And you guys know what a guarantor is. Basically, there's a loan, the wife, circumstances where the husband's got a particular debt. She signs away signs her house to be guaranteed. The business goes broke. She loses her house. And it turns out that the courts will set this aside if it's the wife, but not if it's the husband. So if it's not reversed, it is gender specific. It does not apply to gay couples. It does not apply to de facto couples. How good is that? What is that? That is a quirky rule. And basically, it's an old rule. Yerke and Jones it's old, but so basically, if you are a wife, and by wife I mean the actual gendered female wife, not like the New Zealand Prime Minister's husband, who is essentially a wife. He's a bloke, all right, not like that. But in circumstances where there is a male husband and a female wife, and only a male husband and a female wife, where the wife offers to act as guarantor, and she's not aware of all of the circumstances, the courts will set it aside. Yeah. Yeah. Which one?
98 obviously didn't go well.
Well, Garcia was 1998, and so the High Court had the opportunity to re-examine the rule in Yerke and Jones with a contemporary lens. Guess what they didn't do? Re-examine Yerke and Jones with a contemporary lens. They declined to do so, other than to say, this is still the law. They didn't. They didn't want to. They didn't need to. They didn't think in that situation that it was going to apply. And also they said that, look, they reckon the wife who was seeking in this situation to have the thing undone, she was sophisticated. She was knowledgeable. She knew way more about this. I think she was an accountant, actually. Might have been either a solicitor or accountant. She was a professional woman anyway. And the courts would not... First of all, they said that, look, in these situations, the rule in Yerke and Jones seems really dumb. It seems like an oddity in our law. And what are we now, 2019? That it sits out like a sore thumb, but it's still the law. It's a quirky rule that only applies in that particular set of circumstances. Doesn't apply to gay couples, doesn't apply to engaged couples, doesn't apply to de facto couples, just husband and wife. And what they said in Garcia is that the wife actually kind of knew what was happening. You can't rely on Yerke and Jones if you know with eyes open how this is going to pan out. And so that's essentially what they said there. And they said, but we're not going to disturb Yerke and Jones. No, don't need to. This set of facts, as the way we interpret them, doesn't require us to redo it. So it was a similar thing to have a contract set aside for where there was a guarantee. But in this situation, the woman, so essentially this similar thing to the old case. I think it was actually similar to Yerke and Jones, in that you had a wife, you had a husband, and we would like, for whatever reason, this business goes bad. They asked for this to be set aside, applying Yerke and Jones, and the court said, no, your eyes are open. You can't rely on Yerke and Jones if you knew exactly what was happening. Yep.
That's a very different situation in the sense that they did know what.
Yeah, in that situation they did. Yeah, that's right. And so that's why they're not going to disturb Yerke and Jones, because they didn't reckon it was actually similar to the facts of Yerke and Jones. That's right. Yeah, that's exactly it. So they went, re-examined it and talked about it. So Justice Kirby talked about this in depth in that particular case. But essentially the court said, look, there is no reason for us to disturb the rule in Yerke and Jones. It still remains good law. It is still the law of the state of Queensland and the Commonwealth of Australia. That is the common law of Australia, just as it stands right now. Yep.
Isn't Yerke and Jones, rather than just the fact that they're male or female, it's just one had a lot more capacity to versus the other. So, in the reverse, say you've got a husband that's deal with, and
Yep. Yerke and Jones won't apply. It just won't apply. I'm not saying it's a good rule. It's a really bad law, but that is the law.
So it wasn't really a matter of knowledge.
It did involve knowledge. It was basically, the rule is long-standing. The rule presumes husbands have all of them. Oh, I love this. The rule presumes that husbands know everything about all of the money stuff and wives don't know anything.
Yeah, but back then it was the truth.
Maybe. Yeah, that's right. It's an old rule. It's not. Yeah.
Like going guarantor for a property.
Yep.
Regardless of whether you have a husband or a wife, if you're going guarantor, you're still asked to seek third party legal advice.
Yep.
So
How did it happen that they didn't know that this was happening? Well, again, in that situation, in Garcia, they said the wife knew about it, and that's fine. And all of these things, remember, are rebuttable. And you are going and arguing, first of all, the transaction is fair, and I'll talk about this in the next little mini recording. It's only in situations where there is this asymmetry of knowledge. So you have to have this asymmetry of knowledge, and you have to have that particular combination. Husband is guaranteeing something, and the wife. It's funny because I remember arguing about this like 10 years ago when I studied this with Rachel, and they're saying, that seems really dumb. And she's like, yeah, it's really dumb. And they could have They could have fixed it and talked about it in Garcia and reframed it and said, oh, if Yerke and Jones came up again, we wouldn't bother about this. It would still be obiter, but it would make perfect sense. But the court didn't. They just said, no. Gleeson Court said, no, this Yerke and Jones is still good law. Well, Yerke and Jones still forms part of the common law of Australia. But it has been narrowed somewhat. So first of all, it's not in the UK. UK courts did go through and look at this. Barclays Bank and the Ettridge case, both of those. They looked at that and they said, no, this is not a very good law. This is really dumb. We should look at the circumstances of each individual case. And other courts, this is the federal court, have interpreted it really narrowly. And they said it's only to do with guarantors. Guarantees. So refinancing existing loan, what have we got? Understanding the nature of effective loan, refusing independent legal advice, getting independent, all of these things, look, it means that Yerke and Jones is not going to apply. We don't like it. We're going to find a variety of circumstances to say this rule ought not to apply. All right? A law that says your gender determines, your gender and your marital status determine your legal rights in relation to a contract. Wins. But that is the law. It actually still is. It still is and remains as such. So, all right. So I'm gonna do this. I think I'm actually gonna have to stop the stream very annoyingly. Very short stream.